More than 10 years of legal experience, Attorney Williams is well equipped to help you prepare for and weather the storms of life. Her boutique firm focuses on simple and complex estate planning, Florida probate representation, guardianships, customized wills and trust, powers of attorney, living wills, and general civil litigation. Attorney Williams is down to earth, passionate about what she does, and has a keen ability to form a deep connection with her clients. Attorney Williams' years of concentration and development in these areas have prepared her to provide optimal legal services to meet your specific needs. Contact attorney Vernita C. Williams today to set up an appointment at 305-967-6741. That's 305-967-6741.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
And we are back. This is the Ask the Expert show. We're on every Monday and Thursday from 6 to 7 p.m. drive time. We're on stations 96.9, 95.3 FM, and 1470 AM. Rarely will you hear me say that I love one of our experts, but our next expert, I love this woman, this attorney. I love her, and we're getting feedback from people that have listened to the show who love this lady also. Let me introduce you to. She's not smiling. I thought she'd be smiling when I looked up. Attorney Vernita Williams, one of the finest estate planning attorneys in South Florida, and she cares so much she's even written books. Do you have your book with you?
Yes, I have my book with
Would you
me.
hold it up?
I'm going to hold it up. Can you see it?
Yes. Listen, look at the name. Make a will and do it right. And you put
You got to say the rest
everything.
of the part now.
Well, you put everything into this book.
Yes. Steve, you have to say the subtopic too.
Oh, okay.
You got to say it. It's make a will, do it right. But the other part is, or the one you don't like will end up with all your stuff. You got to say that
Boy,
part
is that
now.
the truth, though? Is that the truth? But listen, we have been getting people loved how you do the show, and
Well, I love talking to them.
you can tell you love educating people. But Vernita, you know what? The way you do it, though, I mean, I think you're very God gifted you to educate people because, you know, some attorneys talk over your head and you have no idea and you're embarrassed to ask. You make it so easy to understand about planning for the future.
Listen, let me tell you something that happened last week, Steve.
Oh, I love
A lady,
stories.
a lady called me and she talked to my assistant, but she said, but I want to talk to the attorney. I want to talk to the attorney. So my assistant said, well, I know she's in a meeting with somebody, but I'm going to give her your number and ask her to call you back. So I called the lady. I talked to the lady about 20 minutes. And she said, well, thank you very, very much. And she said, well, I'm going to call around. I'm going to call around and because I need to find out, what other attorneys are saying and how much they charge and everything. So I started laughing. She
I
said, why
would.
are you laughing? She said, why are you laughing? I said, I'm laughing because I can bet you my colleagues are not coming to the phone and talk to you 20 minutes. You can
Right.
forget it. She said, really? I said, really? Call me back and let me know how that works for you. So
Well,
yes, I do like talking to people.
I thought about you the other day. I had one of my experts on our Dallas show, and this is why it's so important to plan because you never know what's going to happen. I had not heard from him. He's a plastic surgeon 50-something years old. He just died of COVID. Now, people go, I've got plenty of time to put a will together and, I'm still young. You just never know what's going to happen.
No, you don't. You don't know what's going to happen. I've had some deaths very close to me of people who died from COVID. And there was one situation where the family called me about 3 days before the lady died. And they said, well, she's been in the hospital 2 months. She's on a ventilator. Somebody now has to step up to the plate and start handling her business. We need to get a power of attorney. And I said, well, you can't get a power of attorney because she's not awake and alert and able to sign the documents now.
Right.
So now you're going to have to get a guardianship. And I always tell people, if you neglect to do these documents and your family has to get a guardianship, it is much more expensive to get a guardianship and be bothered with the court. And the court has to send out 3 mental health evaluators to the person that you're trying to get the guardianship for. So it's very difficult when you are under duress and having to get things done and trying to do something for your loved one. It's much better if you do it now.
You ever need a lot of people wait till either the last minute or if it's too late, just doing a simple will, they wait too long.
Yeah. And this is not your most favorite subject to talk about.
No.
I admit that, but it's a good thing to get it done.
Vernita, this is a personal question because I know a lot of times the family gets involved with this. And, we just heard this with Larry King's wife. He left all the money to his children and nothing to the wife. And she's not real happy about that. And that really puts you in a strange position.
Well, yeah. If he left all of the money to the children and nothing to the wife, I just wonder what are the documents like behind the scenes? Because in most states, if you are a spouse who has been left out, the estate was given to the children or to friends or charity, wherever. In most of the states, there is something called an elective share. And although your spouse may have elected to do away with his assets or her assets and give them to somebody else, most states have an elective share statute. Florida does, in which a spouse can come in and say, yeah, I know you wrote a will and you gave everything to your mistress or your children or whomever. I still can elect to take. You're laughing, but I do know people who gave their estate
sure
to their
you
mistress.
do.
The spouse can come in and say, okay, yeah, I know you did that, but I'm electing to take my 30%.
Wow.
You see? But yeah, you can come
And
in
that's
and
an
you can
automatic.
do an election. You can do an election, but now you have to look very carefully at what went on behind the scenes, because it may be that some of the things that Larry King had, they may never have been titled in a manner that one could legally say these are his assets. Let's say whatever he had was never titled as his. Let's say it was put in a irrevocable trust and he had no control over it. But maybe it was to his benefit in the sense that he was allowed to spend money from it or whatever. But Larry King was a wealthy man,
Yes.
very, very well known. I don't see him setting his assets up in a manner where whatever he was trying to prevent happening would happen. So although the wife is saying, I'm the wife and he gave everything to everybody, he probably did some fancy footwork behind the scenes where whatever he put together was going to hold up in court.
Well,
But
I heard that
typically,
he left $50 million to his kids, and he wrote it on a napkin. Could that be possible?
Well, if
with
he
all of his
left
money?
if he left $50 million to his kids and he wrote it on a napkin, I guess with no witnesses.
I
See,
don't
in
know.
the state of Florida, you can write on a napkin all you want. You might as well put that napkin in the trash can because
It doesn't mean anything.
because it doesn't mean anything. In the state of Florida, you need two witnesses. Now, you need for it to be notarized, and you need two witnesses. And it is preferable that you have what is called a self-proving affidavit. The self-proving affidavit is not a requirement, but it's good if you have it. But in the state of Florida, writing something on a napkin and signing it, that just won't work. Now, Aretha Franklin, when she died, Steve, they found a last will and testament in her handwriting under the pillow cushion in the chair in her living room. It didn't have witnesses, but it had her signature. And it's my understanding that in the state of Michigan,
Okay.
they are giving that serious consideration. It doesn't just get thrown out because of the lack of witnesses or a notary.
So if Larry King had, say, witnesses, and he's willing $50 million to his kids, his wife can come in and still get 30%?
Well, if the wife has something called an elective share,
Okay.
and his assets were titled in a certain way where you can say these were indeed his assets, and he didn't do any particular thing that helps him get around that legal requirement, then the fact that he had witnesses giving everything to his children does not mean that his spouse has to give up her elective share. I handle a probate case here in Dade, and the lady had not been with her spouse for 25 years. She didn't even know the man had died. She found out he died a month after he died. She then hired me to pursue her elective share, which I was able to get. And he had a will. The man had a properly executed will giving everything to their one daughter, which they had together.
Okay.
The person I represented was the wife, and I was able to sell the homestead property and get her 50% of that money because she executed her elective right to receive that, and I did go after her elective share. So yes, although she hadn't been physically in the household with the man or married to him and was living somewhere else in another relationship, she still was able to get what she was entitled to as a wife despite his properly executed will.
We're going to go to break right now, and we come back. I think one of the great things about you is probate is very expensive, and that's one of the areas you handle. But you're always talking about keeping people out of probate. So
Yes.
I think that is wonderful that an attorney is going to show you. And we're going to talk about revocable trust when we come back. But you always try to keep people from going into probate.
I try to keep them from going, and I always explain to them when they have to go that one of the reasons why I try to keep them from going is probate on a good day is going to be 6 to 12 months when there's not a problem. Now, if you do a summary administration, you can do that one more quickly. But your formal administration will be 6 to 12 months and there is no problem. Folk don't like to deal with handling an estate that long. So for that reason, I do try to keep people out of probate.
We're going to go to break. Give everybody your phone number they can reach you at tomorrow.
My phone number where you can reach me is 786-831-9483. That's 786-831-9483. You can call me there and you can text me. If you text me, I am going to send you a courtesy copy of my book, make a will, do it right, or the one you don't like will end up with all your stuff. Text me and I'm going to send you that as a special gift.
We'll be right back.
At the law firm of Vernita C. Williams, Esquire, PA, you will find a South Florida estate planning attorney and civil litigator who will fight to protect your property, your wishes, and your rights. With more than 10 years of legal experience, Attorney Williams is well equipped to help you prepare for and weather the storms of life. Her boutique firm focuses on simple and complex estate planning, Florida probate representation, guardianships, customized wills and trust, powers of attorney, living wills, and general civil litigation. Attorney Williams is down to earth, passionate about what she does, and has a keen ability to form a deep connection with her clients. Attorney Williams' years of concentration and development in these areas have prepared her to provide optimal legal services to meet your specific needs. Contact attorney Vernita C. Williams today to set up an appointment at 305-967-6741. That's 305-967-6741.
We are back. We're in our final 15 minutes of the Ask the Expert show. We're here with attorney Vernita Williams, and she does estate planning, and she is really, really good at it. We were just talking about before we went to break, trying to avoid probate, and I guess a revocable trust is one of those ways to help avoid going through probate.
Yes, most certainly. It is one of those ways, that is provided the revocable trust is done properly. One of the main mistakes that people sometimes make when doing a revocable trust is failure to fund the trust. If the assets that you are trying to keep from going through probate are not actually placed in the trust in a process called funding the trust, then you don't have an operative trust that keeps you out of probate. That is real important. Sometimes people try to do a trust on their own and they forget the most important part. That is funding the trust or putting the asset that you don't want going through probate in the trust. So it's a good tool. You don't have to go to probate, but make sure you fund the trust.
Now, does a trust prevent court control of your assets after the person dies?
It does. When you have a trust, and it is, as I said earlier, properly funded, that means property that the trust is supposed to control is in the trust. All the trustee will need to do, if the person that set up the trust passes away, is transfer that asset pursuant to whatever the trust agreement says. So if it's a trust and property is in the trust, and the person that set up the trust wants the property to go to person A, then the successor trustee who takes over after the original trustee who set it up will typically just read the trust and do whatever it says. If it says give the property to person A, then the successor trustee will deed the property to person A. Now, if there is no trust, but instead there is a will that says give the property to person A, that will have to be submitted to the probate court, and you will have to do the transfer through court, and it will take much, much longer. But if you have a trust, then the trust is in control of the assets, not the court process, not the judge. You're not waiting on whatever the judge says you can do whenever the judge says you can do it. So no, the court is not in control if there's a trust. The trust is.
Hey, Vernita, we just got a text from somebody who is a New York snowbird. They want to know if you can take care of their estate planning even though they don't live here year-round.
Yes, yes. I do estate planning in the wake of the pandemic by Zoom. I have a lot of Zoom meetings where I see people, they see me. We have a discussion I explain to them some things that are necessary. I share my estate planning charts and things by Zoom. And yes, I can do planning for people all over the country now.
Oh,
And
okay.
I do. Yeah.
So in New York, where
Now
we
they're a
do have,
snowbird.
yeah,
They're a snowbird. They live in Florida part of the time, right?
right,
And in New York,
right. The other part of the time, they didn't.
yes. I
You
can
you don't
definitely
have to
do
be
that.
licensed as an attorney in New York.
I do not have to be licensed as an attorney in New York, but when you're doing estate planning for people in other states, it's extremely important to have a good understanding of the differences from one state to the next. For instance, Florida only requires two witnesses on a last will and testament. There are a couple of states that require three. So you have to check up on the little differences from state to state because you wouldn't want to make a mistake and have two witnesses when New York or some other states require three. And then what you have put together with only two is not valid in the other states. So,
That makes
yes,
sense.
I always make it a practice, especially when my clients have properties in different states. I
Right.
have a lot of clients with property in the Bahamas. I have two cases that involve property in the Bahamas. I have clients with property in Haiti, property in Mississippi, and property in Georgia. So now you have to take a look at the key elements of the estate planning statutes in other states when you see they either live in other places or have properties in other places.
Now, getting back to trust, will the public be able to get a copy of a trust?
Typically, the public will not get a copy of the trust. That is one of the things that people like about it. It is private. Only if a trust ends up in litigation, and I've litigated a couple of trusts, and when there's litigation, then you know it's a court file because it's a court case with a case number, and you can go on your computer and you can pull up a lot of things. But if that trust does not end up in litigation, and most of the trusts do not end up in litigation, then no, it is not made public, it's not in the public record or in some kind of registry. But if it ends up in litigation, folk are going to be able to pull it up on the internet.
Here's a question I'm sure you get a lot of is how long does it take to distribute assets from a trust after a person dies? I'm sure that's the number one question. How long does it take?
It can be done immediately.
Really?
When a trust is set up and property is in the trust and that trust is being managed usually by the person who put the property in the trust, if that person passes away or becomes incapacitated, then a successor trustee steps in. They don't need court approval. They don't need a court proceeding. They don't need to file anything in court. Their name just need to be listed in the trust agreement. And as quickly as they want to make a transfer of property, it's on them. I have set up trusts. Some people, once they get the memorial service taken care of, some people will start setting things up or making transfers or following the directives within a week, some within 2 weeks, some within 30 days. But I can tell you with a trust, you can move quickly. But when you have a will and you've got to go to probate court, you are not going to be moving quickly. It's probably
Right.
going to take 2 or 3 weeks just to get the personal representative appointed if there is no contest about who's going to be the personal representative. So
What
it's very quick.
what about in-laws? Can the in-laws
Well,
can they get anything?
the beautiful thing about a trust is the trust can often keep in-laws from receiving from an estate based upon how the trust is drafted. I had one lady who had 7 children, and when I went to meet with her about her estate planning, I went to her home to see her because she was bedridden and she couldn't come to me. So I went to see her. She said, okay, do a will and create a will and put all my 7 children when I pass away, on my property. I explained to her about doing a trust. She didn't want the trust. She said it was too expensive. So we did a will. We put all of her children on the deed to her property. Guess what happened? Within a couple of years, one of the sons died. And then guess what happened? That
You,
son, the son's wife, became entitled to be part owner of that part that the son owned. The other children didn't like that. But if the woman had created a trust and put her property in trust and made her property for the benefit of her children only, her direct descendants, then it would not have gotten under the control of the son's wife, at least the part ownership that her son had that she gave him through the will. So with a trust, you have a much, much greater opportunity to keep the property where it doesn't end up in the hands of in-laws. It's a lot of folk who they like their in-law okay, but they don't want the
yeah.
in-law to be the direct recipient of their property. You
Before
see?
we go, let's hold up your book.
Here is my book.
Make
It
a
is
will,
titled Make a Will,
do it right,
Do
and
It
tell
Right.
us.
or the one you don't like will end up with all your stuff.
And how do they
That's the
get
name
your
of the book.
book?
If you want to get the book, call me at 786-831-9483, or you can text me. My office will call you back to gather your mailing address, and we will send you a nice little cover letter and the book as a courtesy copy, a gift to you.
Vernita Williams, attorney Vernita Williams, you are the best. I see why people
Thank
love you.
you.
And you'll be back with us again next month with more Ask the Experts. Everybody have a good weekend. Thank you, Vernita.
Thank you.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.